Hello, Gwen, and welcome to Employment Hour in 30. I'm John Scholes, your host, alongside Lior Samfiru. Lots of stuff going on the show today. We'll get to employment law red flags, and when you are a target of termination because of an illness, severance pay calculator, a bunch of phone calls and emails coming up. A busy show all about your workplace rights, your severance, and things you need to know while you're at work 8 hours a day from now till you get really old, generally, is when it happens. So you got to know this stuff, right? But we always start each week, Lior, with the week that was. What is going on?
Well, John, it's really great to be back here and to talk about employment law and workplace rights. The one thing I do know something about. Yep. So it's really great to be able to inform and educate people. It is a privilege to take people that may be confused, maybe even worried and scared about their work situation, and give them the power of knowledge, the power of information. That now they know that they have rights, that the law protects them, and how the law protects them, and what they can do if they have a problem. And that's the purpose of this show. That's why John and I are here every week, is to make sure that if you are struggling at work, if something's happened to you, if you lost your job, or your boss is mistreating you, or you're a victim of harassment, your human rights have been violated, any of those things or more, you know what to do, you know what your rights are, you know who to contact. So stay tuned. Every week we'll talk about those important things. And to get us started on the week that was, let me tell you about a situation that came across my desk. You and I have used the term, don't mess with mama, before.
Yeah, should be right
Should be right there on on those cups. Well, note to our friend Ryan, he should make those cups.
Right.
But apparently some employers are not paying attention. So let me tell you about an employer that pretty much did everything wrong when it comes to this don't mess with mama concept. Now, when we talk about don't mess with mama, we're talking about, in this case, a woman that took maternity leave. So actually she decided to go back to work early after only about 7 months of working. But even though she went back, or 7 months of being off, even though she went early, her job wasn't available for her. Her employer had hired someone else. She was in a managerial position, and the job that she came back to was a non-managerial, more of an administrative position. Now, right off the bat, she could have said, no, I'm not going to do this, that's wrong, but she decided to stay on. She wanted to be the good soldier.
Sure.
And to stay on even though she was essentially demoted. Well, fast forward 2 months later, the company says, well, we can't afford to pay you the managerial rate for this administrative position, so we're letting you go. Wow. Yeah, I mean, you're shaking your head, and for good reason, John, because that was completely and utterly wrong, and it's illegal. So let's start with the fact, John, that the company had the obligation to take her back to the same job when she came back from maternity leave. They can't decide, well, we want to keep your replacement, or we're going to give your job to someone else. You can't do that. And then, of course, once they did do that, now what they're doing is they're letting her go because they decided to give the job to someone else. So that is a human rights violation. That's potentially a constructive dismissal. The employer did everything it could have done wrong. It's also a violation of the Employment Standards Act. And there's going to be significant repercussions for this employer for treating her this way. And it's so obvious. I don't think I need to be educating people that you can't let someone go because they took a maternity leave. You can't demote someone because they took a maternity leave. But I guess apparently we do have to do that. So I want our viewers to understand the lesson here. Very simple, very clear, and there's no exceptions. If you took a maternity leave or paternity leave and you come back to work, you have a right to your same job with the same pay on the same terms. You can't be penalized, demoted, terminated. And if that happens, I promise you that the law is going to come down quite hard on the employer. If that happens, give me a call and we can easily resolve it.
And it's sometimes the case where an employer will do this, and it's not always out of malice. Sometimes it's just they don't have a sophisticated HR department and they didn't know any better, right?
You know what, John? I agree with that in most cases, but when it comes to these things, to me, this is so obvious. You don't need to have a sophisticated HR person to know that you can't let someone go because they took a maternity leave. So I would give employers the benefit of the doubt in many cases. I don't know if I would in this particular situation. They really did make a huge mistake here. And unfortunately for them, there's going to be repercussions.
If you haven't caught the live radio show we do each week, you can do so at employmenthourtv.ca. Find a station near you that will carry that radio show. Take a ton of phone calls each week. And for interest's sake, we like to play them here on this show and get your opinion on how they go down. So we'll get to one now.
My husband, he was a truck driver, 59, working for a company for about 8 years. It got sold to another person, and they kept on all the staff. He had an illness, and he was on a prescription for it. They told him it might not agree with him and make him a bit cantankerous. He did get that way, and he was suspended for a day, and the next day, the company, they called him up and said, bring back the keys, you're no longer working here. And they gave him 2 weeks severance.
Wow.
Pulled the trigger a little too fast there.
Yeah, a little
fast.
too fast,
Yeah.
and which makes it illegal. So let's break this down a bit. So in this particular situation, John, if he's struggling because of health reasons and he's taking medication impacts him, he can't be penalized for that because it's not like he can help it. If there's side effects to medication and because of that you can't do the job the same way or maybe impacts your mood, your interactions with others, that is actually a common side effect of medications. And if your employer knows that that's what's happening, they can't say, well, we're going to punish you for that. You can't punish someone for doing something that they can't help, certainly when it's related to a medical condition. So this is potentially a human rights violation. It actually probably is exactly a human rights violation. This employer would have had to accommodate this person. Part of the accommodation is understanding that they may need some more flexibility or they may need some more understanding of their behavior. As long as this employer was aware that the behavior of the employee is based on their medical condition or their medication, that employer cannot punish them, cannot penalize them, and certainly cannot let him go. So right off the bat, the fact that the company let him go is a human rights violation. But it gets worse. So in this situation, a couple weeks' pay apparently is 2 weeks' pay. So what I've done is I've taken this guy's information, I plugged it in the handy severancepaycalculator.com website. We'll talk about that more in a second. And let's see what that gives us. So truck driver, 8 years of employment at the age of 59. He was given 2 weeks' pay. Well, the severance calculator correctly says that it could be as much as 14 months' pay.
Wow, a little different.
So they only shortchanged them by about 13 and a half months' pay.
Yeah.
So not only is this company in violation of the Human Rights Code, they've wrongfully dismissed him, and that's just an indication how sometimes companies get it wrong, and it's important to understand what your rights are. Your company can't let you go, penalize you, suspend you because you have a medical condition or because you're taking medication. And if they do let you go, please check out severancepaycalculator.com to make sure you know exactly what you're owed.
And emails as well, help@employmenthour.com and 1-855-821-5900. Not that uncommon a thing to happen. It happens all the time. People
All
say,
the
oh,
time.
you're out of here.
And the reason, by the way, we're bringing up these examples, John, it's not because they're so unique
And rare.
Rare and unusual. We're bringing them up because they're common. And our viewers may find themselves, if they haven't already, in these exact same situations. That's why we're talking about it. That's why we want to make sure people know what to do.
Another way to ask questions and get them answered, either you could be straight up about it or they could be anonymous. Terminationquestions.com as well. We pull some of the interesting ones. I'll read one to you and I'll get you to reflect and expand on this one. Again, terminationquestions.com is where you want to go. It says, after 30 years of employment with the same employer, I was asked last month to accept a decrease in duties and pay, shifting from a salary to an hourly wage. Now, being 61, I accepted due to the difficulty of finding other work. Makes sense. Because this is a slow time of year, this is another part of it, I took a 6-week temporary layoff. Because this layoff is now on my record that I've done it, does this mean my past years of employment no longer count? There's a lot here.
There's a lot to digest. So I'll get to the specific question about the length of employment and does that eliminate past years of service in just a second. But let's digest this a bit more. First of all, if the person's compensation was changed, moved from a salary to an hourly wage, that is something a company does not have a right to do. That is a huge change to go from salary to hourly. What that means is the employee would have had the opportunity to consider that a constructive dismissal and say, I'm not going to accept that. And if you make me employer, then I'm going to treat that as a termination, leave with my severance. A lot of people think that they have no choice, that the employer can decide how to pay. Not so fast, not true at all. You have a right to the compensation that you've always had. Your employer can't reduce it, can't change the way they pay you, can't reduce your commission, put you on an hourly instead of salary. They can't do that. So that's issue number one. Issue number two is the temporary layoff. So this person says that they were laid off. Again, the temporary layoff in almost every situation is in fact a termination. A company does not have a right to lay someone off temporarily except in unusual circumstances. And that means that the employee that's been laid off temporarily can treat that as a termination and get their severance. And one of the reasons why you may want to do that if you've been laid off temporarily, by letting your company do that, by letting the company lay you off temporarily and then you come back to work, you give them the right to do it again and again and again. And that's the problem. Same thing with a salary change. If you let them change your salary, they arguably can do it again. So that's a problem. You probably want to be careful and say, no, if you're going to start messing with the terms of my employment, I'm going to leave rather than open that door wide to allow you, employer, to do whatever you want. Bad news. So right off the bat, we had 2 instances here of constructive dismissal. Now, to the specific question is, now that I've allowed them to do that and I've been on the layoff, does that mean my previous seniority doesn't count? The good news is no, it does count. So the fact that you allowed your employer to lay you off temporarily and you came back doesn't mean that your seniority starts from scratch. No, you're still continued employment. You still have continued employment. So down the road, if you are let go, your severance is not going to be reduced. It's not going to be eliminated. So that is the good news. But you want to be careful with allowing your employer to change your compensation and to lay you off temporarily.
You know, it's funny, you mentioned the term down the road, and that's something we echo all the time on this show and on the radio show. It's not so much what they're doing in the here and now, it's the effect down the road that you have to look at 5 years, 10 years, 20 years down the road. That's when it can really come home to roost, right?
Well, let's use a simple example. My employer reduced my salary by 10%. I think I'm not happy about that. Who would be, of course?
Right.
But I'll be the good soldier. I'll take that. I'll continue working. And I'm thinking nothing more of it. But by allowing my employer to do that, I've given them the right to do it again. So what happens if a year later it's another 10% and then another and another? Before you know it, my compensation is a fraction of what it was. So that's the problem with opening the door a crack. Right. Once you open it a crack, it could be kicked wide open, and then the job that you have now may be nothing like the job you'll have in the future, and that's a huge problem.
1-855-821-5900, help at employmenthour.com to reach out to Lior and the rest of the firm. I mentioned off the top we're going to talk about employment law red flags. Here's a big one right here. Despite many stellar performance reviews, could be over some time as well, your employer puts you on a performance improvement plan. It just happens.
Well, usually if you're put in an illegitimate, I call that an illegitimate performance improvement plan, it means that there's an effort being made to let you go. So that's a red flag. You have to be wary of that. All of a sudden, out of the blue, unjustifiably, you get a negative performance review. So what do you do with that? You don't stay silent. You respond to it. You say why you disagree with it. You explain your side of the story. Silence is the same as saying, I agree.
Acceptance, right.
Horrible idea. So if your employer gives you a negative performance improvement plan or a performance review and you don't agree with it, say so. Explain why. Do it respectfully. That is a huge red flag, John.
Talking employment law red flags here. Number 2 is your employer gives you half of your coworker's workload and moves you to an office much further away.
Yeah, that is a red flag. That means you're probably about to be let go. So you want to always be mindful at that point. Let's start ensuring that we have what we need in case we are let go. Let's make sure we have our employment agreement, copy of any policies, copies of any performance improvement plans if they exist. Use the severance calculator, be ready. That's usually a sign, that's a red flag that if you're being kind of pushed away, it's a step towards termination, so you have to be ready.
Another one on this list, a big one, we talk about it again almost each week, and that is after a few years on the job, your employer asks you to sign, oh wow, a new employment agreement, midstream.
Yeah, and you know what, John, if you're, I'll make this very simple. If you're working and out of the blue your employer comes to you and says, I want you to sign an employment agreement, that is bad news, full stop. There's no exceptions to that. Your employer is not going to come to you and ask you to sign an employment agreement that provides for better terms than what you already have. It's not going to happen. So there could be terms in there that limit your future severance, that give your employer the power to change your job. So be very worried, and please, please, please do not sign an employment agreement without talking to me. The repercussions can be huge.
That is help at employmenthour.com, by the way, to reach out, 1-855-821-5900. We are talking employment red flags here. This one is so current and so topical, and that is, you've asked your employer twice, maybe more, to investigate sexual harassment by a coworker, but nothing has been done about it yet.
A huge problem. And certainly if you've been harassed, if you've been mistreated, the right thing to do is to give the company the opportunity to fix the problem. So go talk to human resources, talk to your boss, talk to the owner, give them an opportunity to investigate and to fix the problem. Now, if they don't, that is a problem. And that means you're going to continue to working in a negative work environment. You're not going to have your employer's backup. Before you know it, it could impact your health. You may have problem sleeping and depression. I've seen that happen many times. So at that point, it may be time to deal with it externally. Let's see if I can give the company a kick in the pants, or if I can't or you don't want me to, I can get you out of there with compensation. It's a red flag, it's a problem, it's something you have to pay attention to. If you don't, your health could start getting impacted.
Talking employment law red flags, thing you should be watching out for, and many reasons why you should call Lior and contact him as well. Another one, your employer says you weren't the right fit for the job and fires you, but fires you for cause.
Yeah, it's so difficult to fire someone for cause. And you know what? Maybe let's give the employer the benefit of the doubt. Maybe the person was not the right fit. Fair enough. That does not mean they can be let go for cause. That's a different situation altogether. Cause is reserved for someone that commits a serious workplace offense. So someone that's so bad that it's impossible to employ them. So the fact that you may not have done a good job in a particular situation, or you're not the right fit, does not mean you can be let go for cause. You're still owed your severance, and you don't want to be terminated for cause, because what are you going to tell a future employer? I was let go for cause? That means you're not going to get another job. So if you've been let go for cause, red flag. Unless you've done something horrible, you have to deal with it. Give me a call if that happens, and take that very seriously.
You can be let go, but just not for cause. Full compensation.
Absolutely. Yeah. Full severance. And also the idea that you haven't been let go for cause is important, because when you go look for another job, you want to be able to tell your new future prospective employer, yeah, I was let go without cause. That sounds much better than, yeah, I was so bad employer they let me go for cause. Terrible situation. So if you are let go for cause, call me. Don't wait on it. It's something we need to resolve.
Employment law red flags. We'll get to one more here before we go to break. This one's a big one as well. You're laid off after undergoing major surgery, despite the fact that the boss promising you full-time work when you return from that surgery.
It is a human rights violation to let you go because you had a surgery, because you have a disability or a serious medical condition. So your employer has to let you come back to work. It's not up to them to decide. And if they don't, that's something you have to take very seriously. The law is going to be your friend. The law is going to support you. And if you're let go because of a medical condition, not only you're owed the usual severance, and by the way, you may be owed enhanced severance, but you're also potentially owed other damages, human rights damages. So it's very, very important to take that seriously, get the proper advice.
And, you know, you've also heard many times when it comes to that particular scenario that it's like, in 8 months, when you come back, I won't have a job for you. They crystal ball it all the time. They can't do it, right?
We've talked about this before on the show. They can't crystal ball it. If your employer has an obligation to take you back when you're ready to come back, they can't decide 8 months before that they don't have a job for you. They may not have a job for you today, but you're not coming back today. You're not coming back for a few months. At that point, maybe they're desperate for someone like you to come back to work. So if your employer tries to be overly proactive and say, in the future, we're not going to have a job for you when you're ready to come back to work, that in and of itself could be wrong. That itself could be a human rights violation. So the assessment of whether the company can take you back can only be made at the time you're ready to return, not before.
We'll take a short break. The number 1-855-821-5900. It is help at employmenthour.com. Still to come. You think you're a contractor? Hang on, think again. That and the Severance Pay Calculator coming right up. Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact. The labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact. Over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first. Back with more Employment Hour in 30, as we like to do, and we drill home on this every time, is get to the Severance Pay Calculator, such a key tool, and I think we're getting close to 450,000 visits to this particular tool. Give me some details on it.
450,000, my gosh, I could never have envisioned it when I first created the calculator. So for those that don't know, if those that are seeing us for the first time, SeverancePayCalculator.com is the place you go to if you lost your job. Why? Because it allows you to find out in seconds exactly how much you're owed. It's such an important tool because if you don't use it, if you don't get that information somehow by other means, you may find out later that you've accepted tens of thousands of dollars less than what you're owed. So you go to SeverancePayCalculator.com, you answer 3 simple questions, and you're done. You find out exactly how much you're owed. Age, position, length of employment. That's all you have to put in. And then you find out whether you're owed 6 months, 12 months, 24 months. It's so important. It's anonymous. It's easy. It's free. There's no strings attached. You don't have to put in the company name, so don't worry about that. And if you think you know, like, I don't need to use the severance calculator. I know I'd get a week's pay per year or 2 weeks. Wrong, wrong, wrong. Check yourself right now. Go to SeverancePayCalculator.com. Don't take my word for it. Use it. And you know what? If it was the amount that you thought, send me an email and let me know. I bet you it isn't. severancepaycalculator.com.
We'll run through a scenario and we'll show you how it works. Got one here, says, I'm a senior manager making about $100,000. After 17 years of hard work, I was fired as they wanted to slowly phase out my position. They gave me 44 weeks of working notice. I didn't sign anything or even get to negotiate. But a few weeks later, they decided to cancel the whole thing, and now I'm out of work. Should I contact the labor board? First of all,
No. Like run far away
Quickly.
from the labor board. You cannot go to the labor board if you lost your job. All joking aside.
Yep.
You can go to the labor board if there's an overtime issue, a vacation pay issue, a statutory holiday issue. Absolutely. Please do. You cannot, should not, under any circumstances, go to the labor board or to the Ministry of Labor if you lost your job, because they can only help you with respect to your minimum entitlements. So this person, let's see what they're actually owed. What I've done is I've taken the information from this question that we received, I plugged it into the severance calculator. So let's look at that. So a senior position, senior manager, 17 years of employment, the age of 54, salary of $100,000. Well, they were given 44 weeks notice. By the way, they weren't even given that because they took that away.
Yeah.
But they're actually owed 18 to 24 months of severance. So even if they had received that 44 weeks of notice, that's still somewhere between $65,000 to $115,000 that they're still owed. This is not a made-up number. This is what the law says. That's what I want people to understand. This is not an opinion. This is not a nice to have or a pie in the sky. This is what the law says this person should have, and I bet you're the same way. If you lost your job or are worried about losing your job, maybe you're concerned, you're seeing the writing on the wall, go to severancepaycalculator.com. Be prepared. Be armed with that information. Don't be taken advantage of.
and again, this isn't a bizarre or rare scenario. This is very common, this type of thing.
It is extremely common. Most people that use the calculator find out that they're owed 5-10 times more than what they know, what they realize. And if you want to, when you go to severancepaycalculator.com, there's a green button at the end you can press to contact me. Only if you want to. You don't have to. That way I can help you actually get what you're owed.
EmploymentHourTV.ca. I want to check out where you can find our live Employment Hour radio show. We'll get to a call from that show now.
I've been teaching a class about 9 years, and they say that I'm an independent contractor, but what I was reading online is that if I work in a place that I use all their equipment, I'm considered their employee. So I'm not sure.
Yeah.
Yeah.
Very good question. Now, by the way, very common with teachers, instructors, and colleges. Oftentimes they're called independent contractors. So let's start with the proposition that what they're being called or what they think that they are is irrelevant, okay? The law decides if you're an employee or a contractor, whether or not you signed a document that says you're a contractor or not, doesn't actually matter. Now, for this particular person, if they've been working somewhere consistently for 9 years, if she's using the school's equipment, materials, she is very likely to be an employee, John. There's going to be very few exceptions to that. You know, if it looks like an employee, if it acts like an employee, it's an employee. Doesn't matter what you call it. So because of that, that means she has certain rights. She potentially can claim for overtime and vacation pay. But just as important is if the school lets her go, they may say, well, you're an independent contractor. We don't have to pay you any severance because you're not an employee. But wait a second, she really is an employee. Therefore, she gets severance. That's the lesson that I want our viewers to understand here. It's very important. If you lost your job and you think you're an independent contractor, unless you really are an independent contractor, and most people are not, you probably are owed your full severance, the same as any other employee. So don't assume that you are an independent contractor. If you're a plumber going from house to house fixing leaks, you're probably an independent contractor. If you go work for a company, you have a regular job, you've been doing it for a while, you're an employee, even if you call yourself something else, even if you invoice the company, even if you have your own corporation, even if they don't withhold taxes, you're probably still an employee and you have the rights of an employee, especially when it comes to severance.
You know, we touched on it a short time ago, a few minutes ago, with the Severance Pay Calculator, and that is how to avoid the Ministry of Labor, when to avoid the Ministry of Labor. And that's where we're going to pick it up after a short break. 1-855-821-5900 and help@employmenthour.com.
Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact, over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact, in most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first.
Welcome back to Employment Hour in 30. We have a live radio show that happens as well. We've been doing that for a very long time. We get a lot of phone calls. We play a lot of phone calls, the ones of interest. If you want to find out where to catch that radio show, employmenthourtv.ca. Let's get to another call, right?
I was let go without cause, and I was working with the company for about a year and 7 months. I was recruited out of a different company to become a store manager. Upon perfect results for the store hitting targets, about 5 months later, they came in and said they were investigating me for allegations. 3 days after that, I was handed a letter saying I was let go effective immediately with no cause. They just offered me 2 weeks' pay plus my vacation time owed, and I didn't sign any paperwork or anything.
Yeah. Well, here's the thing, John, and obviously it's frustrating for this individual to be let go. He didn't do anything. But unfortunately, we can start from the proposition that the company is allowed to let him go as long as proper severance is paid. He may not have done anything. So, you know what? It would be unfair for the company to let him go for no reason. But legally speaking, even though it's unfair, they're allowed to do it. But severance has to be paid. So that's the issue for this gentleman. The fact that is 2 weeks severance enough for him? Now, one of the things he said in this call is that he was recruited from another job, and that's key. I would want to find out how he was recruited. Was he looking to leave? Because if you're recruited from another job and then let go shortly thereafter, like this gentleman was, you actually may be owed enhanced severance that recognizes your service with the previous company. So you may have only worked for the company for a year, but you had 5 years with the company you worked with before, and you were recruited from that company. So when it comes to calculating your severance, you actually may be considered a 6-year employee. So that's key. Now, we don't know exactly what happened, but let's take the information that we do have, and let's plug that into our trusty severance calculator. Let's see if 2 weeks is enough. So he's been there as a store manager, middle manager for a year and a half, and he was offered 2 weeks' pay. The severance calculator correctly says that he should have gotten 3 to 4 months' pay. So irrespective of what his income is, the difference between 2 weeks and 4 months is huge. It's significant. Now, John, he actually may be owed a lot more than that, depending on whether he can show that he was recruited from another job. That's why it's so important to get proper legal advice if you're let go.
I'll run through a quick employment scenario as we get down to the last couple minutes here. Gita was just let go from her sales job after 9 years. Out of the blue, her employer says she's not owed any severance because she hasn't been working that hard lately. Gita's brother is telling her to call the Ministry of Labour, there you go, rather than a lawyer. He says it will take years for a lawyer to finish her case. What route should Gita take?
Well, you know, I am positive that her brother has nothing but her best interest at heart, but that's the wrong advice. It absolutely is wrong. The Ministry of Labour can only help her get her minimum entitlements. So for her, those minimum entitlements could be as little as 8 weeks' pay, but she could be owed a year's pay or more than that. So she can't give up those rights. Now, a lot of people say, I'm not going to get some advice because I'm afraid about the process. It's going to take too long. Here's the thing, John. Most employment disputes resolve very quickly, usually within weeks. Faster, by the way, than the Ministry of Labour does. So if you're concerned about the process, don't be. Give me a call. You don't like me, call another employment lawyer, but please, please, please don't go to the Ministry of Labour. You shouldn't be afraid of the process. It's fast, it's efficient, and the law is quite good in protecting employees.
And once you go to the Ministry of Labour, sometimes there's no turning back, right?
No, you're stuck in that process. You give up those rights literally, and you could be giving up tens of thousands of dollars. That's just a fact.
The contact is easy as we close for here for another week. It's 1-855-821-5900 is the number. Help at employmenthour.com and, of course, employmenthourtv.ca. As I mentioned several times during the show, we do a weekly radio show. Good time to chime in and see what's happening on that. That's an hour long as well. So we'll join you next time here on Employment Hour in 30.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.